Welcome to another episode of the podcast, My 2 Cents, a Zambian Case Law podcast. For those of you that are joining me for the first time, this podcast has been running for 2 years now. This will be my 18th episode, but this will be the first episode on the Anchor platform. I decided to switch from Speaker platform that used to do my distribution to the Anchor platform. So I'll leave a link in the description below for the previous episode so that you can catch up. For those of you that have been listening to the podcast, everything continues as usual and we will be talking about episode 18. So welcome to the My 2 Cents, a Zambian Case Law podcast on the Anchor platform with me, George Chintanko Malipula. The citation for today's case is Thomas Mumba versus the People, 1984 Zambia Law Report, and it's found at page 38. Now, the case of Thomas Mumba versus the People is a High Court judgment, meaning there was never an appeal to the Supreme Court at the time because we did not have the Court of Appeal. Now, the area of the law that this case is focusing on is on constitutional law, and is also focusing on criminal law and criminal procedure and evidence law. On the side of constitutional law, it's focusing on the inconsistencies between a provision of the Constitution and an Act of Parliament. Which of the two should we follow in the event that has happened? On the criminal law side and on the evidence side, it is the issue of, can an accused person be compelled to give evidence? Basically, can an accused person only be allowed to give sworn testimony, and the accused person cannot be allowed to give unsworn testimony? So, when we get back, we'll be discussing the brief facts that arose from this case. The case of Thomas Mumba versus the People is a criminal law matter. This matter was in the subordinate court of the Republic of Zambia, where the applicant, because there was an application that was made to the High Court, but in the subordinate court, Thomas Mumba was standing trial for the offense of corruption by public practice. Now, it is alleged that Mr. Thomas Mumba had committed an offense under the Corrupt Practices Act. Now, the issue that arose here was the fact that Section 53(1) of the Corrupt Practices Act provided that if a defendant wanted to say something, it must only be by oath. Whilst when it came to the Constitution and Article 20, Sub-Article 7, it provided that an accused person shall not be compelled to give evidence, meaning an accused person could remain silent, an accused person could give a testimony, but that testimony would not be under oath, so it would be an unsworn statement, so no one can cross-examine you to verify the truth. This then led to a problem because you had Article 27(2) of the Constitution and Section 53(1) of the Corrupt Practices Act contradicting one another. As a result, this matter had to be referred to the Constitutional Court, to the High Court of the Republic of Zambia, pursuant to Article 22, Sub-Article 2, which says if there's a contravention or if there's a question of law regarding the contravention of Article 11 to 27, just basically human rights provisions under our Constitution, and it's in the subordinate court, the matter is in the subordinate court, you have to refer the matter to the High Court for determination only on the constitutional issue. So therefore, as a result of these two sections contradicting one another, this matter was then referred to the High Court to be determined on a constitutional issue. The issue for determination before the High Court of the Republic of Zambia was simply whether Section 51 of the Corrupt Practices Act contravened or contravenes Article 20, Sub-Article 7 of the Constitution of Zambia. As I've already stated, Section 53(1) of the Corrupt Practices Act stated that if a defendant was to say something, it must be by oath, whilst Article 20, Sub-Article 7 of the Constitution provided that an accused person shall not be compelled to give evidence. So, the issue that was before the High Court was whether the Act of Parliament contravened the Constitution of the Republic of Zambia with regard to an accused person giving evidence. The High Court of the Republic of Zambia, in deciding the matter, stated that when it comes to an accused person in a constitutional democracy, he has the right in a criminal trial to either remain silent and not give evidence on one hand, or he has the right to elect to say something. But when he elects to say something, he can choose between one, giving oral evidence, or saying something by way of unsworn evidence. So first of all, they found that Section 53(1) of the Corrupt Practices Act in a constitutional democracy was not right, because it more or less prevented the accused person from either remaining silent or from choosing between giving evidence or saying something basically by unsworn statement. Secondly, and which is the most important aspect, they then clarified the issue with regard the aspect of the inconsistencies between an Act of Parliament and the Constitution of the Republic of Zambia. The High Court noted that under Article 1(1) of the Constitution of the Republic of Zambia, it clearly states that the Constitution is the supreme law of the land. That therefore means the Constitution is the first law of the Republic of Zambia. Being the first law of the Republic of Zambia, it is from where all laws are enacted from, meaning each and every law must reflect what is provided for in the Constitution. Failure to clearly provide for what is provided for in the Constitution, that provision, not the whole Act, that provision will be inconsistent and shall be declared null and void. Therefore, Section 53(1) contravened Article 20, Sub-Article 7 of the Constitution of the Republic of Zambia. Article 27 gave an accused person three options. 1, the right to remain silent. 2, the right to give evidence on oath. And 3, the right to give an unsworn statement. Whilst Section 53(1) of the Corrupt Practices Act only allowed Mr. Mumba to say something on oath or give evidence and did not take into consideration these other provisions. Therefore, the decision of the court brought to the conclusion or brought to the argument the fact that an Act of Parliament cannot contradict the Constitution, and if such a case happens, then the Constitution shall always remain supreme and the Act of Parliament shall always be subordinate and must therefore reflect whatever provisions are provided for in the Constitution, or it will be declared null and void and will be inconsistent to the extent of its inconsistency. My 2 cents talking points on this issue is, first and foremost, when it comes to a criminal matter, the High Court in Thomas Mumba versus the People have ruled on whether or not an accused person can be compelled to give evidence or whether or not he can be allowed to give only sworn evidence. Therefore, from this case, we now see that if you're an accused person, you have an array of options. Meaning, 1, you can give evidence that is not on oath, an unsworn evidence, you'll not be cross-examined. can remain silent, that is 2. And 3, if you want, you can give evidence on oath and you can be cross-examined on the issue. Secondly, if there is a criminal matter in the subordinate court and there arises a constitutional issue from that specific case, then the criminal trial will have to halt and the matter will be referred to the High Court, but only if it has to deal with issues bordering on Article 11 to Article 27 of the Constitution of the Republic of Zambia. If it borders on anything outside those provisions, you now have to take it to the Constitutional Court, who will have to determine the constitutional issue. However, where there is an Act of Parliament and there is a human rights provision, and that Act of Parliament in a criminal trial is seemingly or likely to have contravened the Article 11 up to Article 27 of the Constitution and the human rights provisions, you can actually take that matter to the High Court, or stop the case and take that question to the High Court so that they determine whether or not that Act of Parliament contravenes or is in line with the Constitution. The other point to also take into consideration is that the High Court actually has the right to determine whether or not an Act of Parliament that is enacted or was enacted by Parliament is in conflict with the law, which is the Constitution, and they also have the power to order that it be severed or removed from that Act of Parliament if they find that it has actually contravened the Constitution, like as it was in the case of Thomas Mumba versus the people. So meaning Parliament may enact laws, but there is a way that we scrutinize these laws, and one such way is this method of questioning the constitutionality of an Act of Parliament enacted. Is it in line with the Constitution, or is it in line with our human rights provisions? Thirdly, the Constitution of the Republic of Zambia, including the current amendment number 2 of 2016, is the first law in this republic, and it is the highest. It is from this law that all other laws must reflect their provisions. So meaning, when an Act of Parliament is enacted, that Act of Parliament is just not enacted. It must follow the provisions of the Constitution. If that subordinate law does not follow the provisions of the Constitution, those provisions that are being contested may be severed from that act, and Parliament will have to amend them because they do not coincide with the Constitution. If you look at Section 7 of the Constitution of the Republic of Zambia, number 2 of 2016, it is clear when it talks about the hierarchy of the laws in our country. 1, it says that the laws of Zambia shall constitute of the Constitution itself and an Act of Parliament, which is enacted by Parliament. So if you see that chronological order of the Constitution and the Act of Parliament, as such, if the Act of Parliament is not in line with the Constitution, then those provisions must be removed from the Constitution of the Republic of Zambia. Number 4, an accused person has a constitutional right to either give evidence, which would be by giving an oral statement, or he can give an unsworn statement and you won't be cross-examined. With the oral statement given on oath, you will be cross-examined on the issue. Also, the fact that the court can only order that an Act of Parliament is unconstitutional. The court cannot then and right there amend the law. That is the job of Parliament. As has been seen in the case of Thomas Mumba versus the people, the High Court ruled that Section 53(1) was unconstitutional and that it ought to be severed. Therefore, the job was for Parliament to now repeal or amend that provision and remove it from that Corrupt Practices Act. I'm not sure if the Corrupt Practices Act is still a law in the Republic of Zambia. I think it was amended. So, lastly, that despite Parliament making laws, the Constitution has given the High Court, through Article 28(2), the constitutional review power to ensure these laws enacted are in line with the provisions of the Constitution. As I have earlier mentioned, we're now basically seeing the fact that the laws that are being enacted are actually monitored, and that if they are found to be inconsistent, those laws will be severed from that specific act of parliament and cease to exist. Therefore, the case of Thomas Mumba versus the people is very important because it therefore describes the structure of an act of parliament and a constitution. That an act of parliament is a law that is enacted by parliament, providing for the powers, duties, and responsibilities, and that the constitution is the law that has the fundamental provisions, and it establishes offices, and it also establishes constitutional offices such as that of the president, the attorney general, and many others. And that an act of parliament can never be part of the constitution. No, it's a separate law. It's a subordinate law. An act of parliament should only mirror the constitution, but is not part of the constitution. So this has been your host, George Tintamkwamani on the first episode on the Anchor platform of the My Two Cents, a Zambian Case Law podcast. Until next time, I hope you've enjoyed, and I will see you. Bye.